Either offerer or offeree fails to perform his duties, then it is called a breach of contract, as happened here. 15 June 2018, John informs Peter that he will not be able to provide the token amount on the said date, thereby expressing rejection of the contract. John has all the rights to cancel the contract and file a case on Peter for not fulfilling the terms of the contract. Warm welcome to 4th Sem BCom student. The subject we're discussing business regulatory framework. I'm Professor Rajesh Ella from Department of Commerce and Management from Vidhyaashram First Grade College Temple of Excellence. In our previous session, we discussed contingent contract, discharge of contract, modes of discharge of contract. It is a compulsory question will be there on discharge or modes of discharge of contract on the examination point of view. The last concept what we have here, breach of contract, remedies for the breach of contract as per section 73 to 75 as per ICA 1872. First, let us know about the breach of contract. Breach of contract is nothing but here, either offerer or offeree fails to perform his duties, then it is called a breach of contract, as happened here. Now, it may be further proceeded or it may be stopped where any one of the person fails to perform his duty. The contract may be cancelled due to the non-performance of the duty either by the offerer or offeree. This is a concept what we have here. Let us take anticipatory breach of contract. Let's take example here. Peter enters into a contract with John on 30th May 2018. So, contract was made on 30th May 2018. In the contract, Peter agrees to sell his house to John provided he receives a token amount of rupees 5 lakhs. If he receives 5 lakhs from John before 30th June 2018. So, within 1 month, if John makes the payment of 5 lakhs, he is ready to sell his residential property. Peter is ready to sell his residential property to John. 15 June 2018, John informs Peter that he will not be able to provide the token amount on the said date, thereby expressing rejection of the contract. On 15th June, after 15 days, Mr. John has said clearly that to Mr. Peter, I'm unable to make the payment before 30th June, so let us cancel the contract. This is a concept what we have here. Next one. Peter enters into a contract with John on 1st June 2018. As per the contract, Peter agrees to sell his guitar to John on 10th June 2018, that is 10 days, for an amount of 5,000. However, he sells his guitar to Oliver on 7th June 2018. Here, it is an anticipatory breach of contract due to Peter's conduct. They're saying that one. Peter agreed to sell his personal asset to John before 10 days or on 10th. We made an agreement where Peter is making an agreement on 1st of June and the personal asset will be sold to you on 10th of June. But unfortunately, Peter has sold the personal asset on 7th June to a third party. Now, Peter has made a breach of contract. This is the thing what we have here. Treat the contract as cancelled and file a suit against the other party for damages. Now, John has all the rights to cancel the contract and file a case on Peter for not fulfilling the terms of the contract. Or he can choose to cancel the contract but treat it as an operative and wait until the time of performance has passed before holding the other party responsible for the damages caused due to non-performance. So, here either I can wait till 10th, then I can file a case. First, let the contract get cancelled, then I can claim for the damages through the court for the damages which has happened for not performing the contract terms, whatever it was between Peter and John. Peter enters into a contract with John promising to deliver 50 bags of cotton to him on June 30th. However, on the scheduled day, he fails to deliver the same. This is an actual breach of contract. Also, this breach is at the time of performance of the contract is due. Means Peter agreed to sell 50 bags of cotton to John when on 30th June 2018, but he fails to deliver on 30th June 2018 due to uncertain reasons. Now the time is lapsed here and the contract is still due as per the contract made between Peter and John. During the performance of the contract, an actual breach of contract can also occur when one party fails to perform his obligation. During the performance of contract, this refusal can be expressed in words or by action. Here, either orally I can communicate or in a written format I can send information about the concept of rejection of contract between the parties. Either offerer or offeree can communicate the information to other party either by orally or in a written consent stating that the agreement will not be performed due to uncertain reasons. The same concept has been explained here with the diagrammatical. After writing all the information in the examination, write this diagram where you can score marks easily and get full allotted marks. Next, we have here remedies for the breach of contract. Rescission of contract. When one of the party to a contract does not fulfill his obligation, then the other party can rescind the contract and refuse the performance of the obligation. As per section 65, it says that when the party that rescinds the contract must restore any benefits he got under this said agreement. And section 75 states that the party that rescinds the contract is entitled to receive damages and or compensation for such rescission. They're saying that section 65 and section 75 of ICA 1872 states that when we are given the contract or when we made a contract and if we are going to fail to perform the contract at that point of time, what they have to do, the person who has received the benefits, he has to repay all the benefits whatever he has received, or he can claim for the damages what it has happened. Sue for damages. You have all the rights as per section 73 for claiming the damages as per the terms of the agreement. Next, sue for specific performance. You can claim only for the specific event which has been not performed for certain things. On that specific concept, you can claim the damages whatever it has happened here. Injunction. Injunction is basically a decree for specific performance but for a negative contract. So a court may grant an injunction to stop a party of a contract from doing something he promised not to do. So here they're making him to stop to perform his duties for which is an impossible event which cannot be done here. Quantum merit literally translate as much is earned. At times when one party of the contract is prevented from finishing his performance of the contract by other party, he can claim quantum merit. Whatever the benefits is possible, claim up to that level of benefits, that is called quantum merit, which supports you in case of failure of the contract has been happened between the parties. Thank you to all 4th Sem BCom students. Here we have completed Indian Contract Act 1872. Go through all the units, sessions properly and get through in the examination with the information whatever we have provided. Namaste to all. In the next session, we are going to discuss about Unit 2, Sale of Goods Act 1930. Thank you once again.